Hello. Hi. Welcome, everyone. Most of you in the audience currently know me, but for those of you tuning in on the live stream, my name is Shannon Tagawa-Mercer, and I'm the editor-in-chief of the Georgetown Journal of International Law. I'd like to thank you for joining us today to explore concepts of international justice. I know you're not here to hear me speak, so I'll make my remarks brief. Here at Georgetown Law, our motto is law is but the means, and justice the end. Given today's political upheaval, we at the Journal thought it has now become crucial to step back and reflect on how we, as a community of international law scholars and practitioners, define the goals of our actions, the goal being justice. Over the next 2 days, you'll hear from students, practitioners, and professors on a variety of topics, some of which you see in the headlines on a daily basis, such as this administration's approach to international legal issues, to cyber warfare, and to cross-border law enforcement. Others you may rarely encounter, such as the international crime of sextortion, and the maritime arms trade, sanctions, and natural resource issues. We hope that, through these presentations and conversations, you experience the rich dialogue between international law and international justice, not as a formalistic causal relationship, but as one that requires explicit definition and redefinition as we see our global order approaching increasingly uncertain times. With that, I'd like to introduce our symposium editor, the woman behind this conference, Ms. Noor El-Kebi. Thank you, and we hope to see your faces frequently over the next 2 days.
Thank you, Shannon. Good morning, everyone. My name is Noor El-Kebi. I'm the symposium editor for Georgetown Journal of International Law, and very, very pleased to see you all here today. Thank you for coming. I'll just give a brief introduction to our speaker. Christine Anderson is a Georgetown 3L who has been a member of the Journal since her 2L year. She is an absolutely fantastic addition to our Journal. We are extremely lucky to have her both on the Journal and presenting here today. She will be speaking on the sanctions, transparency, and accountability, the missing links in natural resources anti-corruption efforts. Christine, please take the stage.
Hello and good morning. I'm going to start with a bit of audience participation. First, can I see a show of hands if you've heard of conflict diamonds? Now, can I see a show of hands if you know where to find tungsten or tantalum in daily use? No. Okay. The answer is as close as your pocket or purse. Cell phones all contain these two things, as do many of your other electronics. And these minerals can be just as problematic as blood diamonds, even if they're not as widely recognized. The Democratic Republic of Congo is a major producer of tantalum and tungsten, as well as tin and gold. These minerals are commonly referred to as the 3 Ts, or 3TG. Mines in the DRC are traditionally controlled by violent militias who use sexual and physical violence to force local communities to work in the mines. Child soldiers are the norm, and with many armed groups fighting for control of rich mines, local communities suffer the same abuses at many different hands. The human rights situation is dire. Today I'm going to talk a little bit more about diamonds, other minerals, and timber, natural resources that are commonly exploited in resource-rich areas and sold with varying degrees of knowledge by the sellers to consumers around the globe. Mostly I'll focus on the efforts to combat natural resource corruption through multilateral sanctions, voluntary reporting mechanisms, and US law. Hopefully by the end of my talk, you'll be a bit more informed as a consumer and a legal practitioner, but don't worry, I'm not trying to make you give up your phone or your jewels. The goal is to move toward mining these resources without leaving a bloody trail, and we're already on our way there. In my research, I set out to answer several key questions. What, if any, is the continuing role of natural resource sanctions in the evolving efforts against natural resource exploitation? 2, are the transparency regimes currently in place effective? 3, most importantly, if not, what are alternative means to combat this problem? In the natural resource sector, control over commodities can mean great power and dominance. As such, corrupt dealings are particularly rampant when state mechanisms for resource management fail. In the event of resource management collapse, corporations have a tough decision to make. For instance, in the early 2000s, the dot-com boom pushed tantalum suppliers to find new sources quickly. The reserves of the DRC were vast and largely untouched at that point, so processors quickly tapped into existing smuggling networks, using Rwanda as a transit point. Similar illicit networks sprung up to smuggle Congolese gold through Uganda. Global Witness first brought conflict diamonds to the attention of the wider world in the year 1998, less than 20 years ago. In an expose highlighting the role of companies and governments in fueling conflict in Angola, Global Witness shamed the world for its ignorance of this tragedy. And it worked. In May of 2000, Southern African states gathered in Kimberley, South Africa, to discuss how to stop this flow of conflict diamonds. In December of that year, the UN General Assembly passed a landmark decision recognizing a need for a global certification scheme for rough diamonds. By 2003, the product of these efforts, the Kimberley Process Certification Scheme, came into force. I was introduced to natural resource exploitation a bit later at the US mission to the UN Sanctions Unit. As I pored over dozens of pages of reports on enforcement and violations in Cote d'Ivoire, Sierra Leone, and Liberia, I learned the intricacies of extraction, smuggling, and sale of resources harvested under brutal and sometimes deadly conditions. As recently as the 1990s, there was virtually no oversight of the international movement of diamonds or other minerals. Countries that produced very few diamonds were exporting billions of dollars worth, laundered from neighboring countries. As much as a fifth of the world's rough diamond trade is estimated to be illicit in some manner, tied to theft, tax evasion, and money laundering. Not to be outdone by its mineral exploiting counterparts, illegal logging generates $10 to $15 billion per year in criminal proceeds, with illegally harvested timber comprising as much as 90% of the world's timber market. 90%. Luckily, companies, governments, civil society, and international organizations are trying to combat this problem despite our insatiable need for new and better technology, gems worthy of marriage, and exotic wooden furniture. The past decade has been an exciting time for natural resource watchdogs. Through the Multilateral Extractive Industries Transparency Initiative, the Diamond Origin Tracing Kimberley Process, and US laws requiring transparency around conflict minerals and banning importation of illegally logged timber, strides are being taken to right the exploitation of the world's most mineral-rich areas. Since this symposium is focused on international justice in the US context, I'll speak mostly on the US laws involved in combating this global problem. Dodd-Frank is best known as a banking bill, but it includes an important transparency provision on conflict minerals that is specific to the DRC, Section 1502. This provision requires disclosure of chain of custody information related to the extraction and further processing of the 3 Ts and gold. Thousands of US companies now have to publicly disclose any sourcing of minerals from Central Africa, as well as the due diligence steps being taken to ensure that these minerals do not fund armed conflict. Company websites must reflect their status: DRC conflict-free, DRC conflict undeterminable, or, the worst, not found to be DRC conflict-free. As you might expect, this new law sent corporations into a bit of a frenzy. Nothing like this had been imposed before. Tracing minerals back to their sources would be difficult, expensive, and in some instances, impossible. They didn't know where to start. But there is not any criminal sanction involved in failing to be DRC conflict-free. Instead, the scheme relies on public scrutiny. It relies on consumers to care whether the company's products are conflict-free or not. One major critique of Section 1502 is that it pushes businesses too hard, moving them to find other sources of the 3 Ts, thus establishing a de facto ban on minerals from the area. A de facto ban would negatively affect those whose livelihoods rely on the mines instead of helping to fix the problems in the DRC. But the outcomes on the ground have been largely positive. Given the security situation in the DRC, mines cannot be certified as conflict-free unless they are entirely free of armed groups, including the hugely corrupt National Army. While the newly minted mining police across eastern Congo have also been accused of bribery and extortion in some instances, they are largely seen as a welcome alternative to militia control. Section 1502 has thus been credited with shining a light on illicit actors, making it more appealing to deal in legal minerals which fetch a higher price. As of January 2016, 166 mines in eastern Congo had been assessed by multi-stakeholder groups and validated as conflict-free. Virtually all mines were controlled by armed groups prior to Dodd-Frank, as recently as 2010. While the Dodd-Frank conflict mineral provisions pose no legal risk for corporations, the Lacey Act amendments of 2008 take a different, more toothy approach. The amendments expanded the law's prohibited forestry activity beyond U.S. borders. It is now illegal in the U.S. to have any involvement with logging that is illegal under the applicable laws of the land where the timber is harvested. The Lacey Act thus brings the muscle of U.S. courts into nations with weak or ineffective legal systems. The Lacey Act's prohibition on illegal logging in other states was the first of its kind. Once a wildlife and plant crime law limited to native U.S. flora and fauna, the Lacey Act now gives international manufacturers and marketers new incentive to ensure that their goods are legally sourced. Sizable fines have been imposed on companies that fail to exercise due care in their wood sourcing. Ignorance is no longer bliss in this industry. Serious criminal sanctions follow customs declarations that are found to be false, and prosecution can extend beyond the importer of record. By criminalizing every point of the supply chain, the Lacey Act bypasses some of the gaps inherent in the popular Foreign Corrupt Practices Act. Not only the intermediate buyer is prosecutable, the seller is as well. To date, mostly large operations have been investigated, but smaller operations are not off the hook. The hope is that more businesses will turn to proactive compliance measures as a cheap and safe alternative to prosecution, like we've seen in FCPA compliance. But the U.S. was never the biggest market for illegal timber, so even strict Lacey Act enforcement will only scratch the surface. Looking globally, the Extractive Industries Transparency Initiative is a multi-stakeholder initiative launched in 2003 that involves representatives from the governments, extractive industries, and civil society of member states around the globe. EITI was formed to encourage companies and states to address key governance issues surrounding oil, gas, and mining sectors through transparency. The data from EITI is designed to help governments address weaknesses in their natural resource governance, but so far the data has been patchy, showing uneven effects on public companies versus private or government-owned. Combined with the obvious lack of teeth in instances of noncompliance, EITI is not enough to change natural resource governance on its own. Turning back to diamonds, the Kimberley process traces a diamond from its origin mine to the jewelry store, certifying each step of a diamond's journey through chain of custody monitoring. Under current KP standards, member states can only trade with other participants who have also met the minimum requirements of the scheme. KP certificates must accompany all international shipments as well. The current participants comprise 99.8% of the world's production of rough diamonds, but unfortunately, fake certificates have surfaced from the DRC, Ghana, Angola, and Malaysia in recent years. Despite the good intentions of the Kimberley process, the nature of certification is such that a corrupt government official can provide most of the necessary paperwork without any of the accountability legwork. And then there are sanctions. Though all of the natural resource extraction provisions of UN sanctions in sub-Saharan Africa have been lifted, their effects largely remain. Conflict diamonds and timber regimes required compliance with the Kimberley process or another certification scheme in order to confirm that illegal mining or logging is no longer occurring in the state. These certification schemes are still in place in previously sanctioned countries, and yet, experts say that in war-torn African countries, the illicit minerals trade is still alive and well. This transition from sanctions regime to transparency regime suggests that the relationships between sanctions and transparency is inverse. More transparency, less need for sanctions. But the reality is far more complicated. No one has yet devised a foolproof solution to natural resource corruption or its root causes. Governance is low and desperation is high. Robert Klitgard famously equated corruption to a simple formula. Corruption equals monopoly plus discretion minus accountability. Unless accountability factors in more prominently, transparency alone will not solve these problems. For instance, expulsion from the Kimberley process has not stopped the Republic of Congo, a neighbor to Democratic a neighbor to diamond trade giants Angola and the DRC, from serving as a superhighway for the illicit diamond trade. So what do we do? With neither sanctions nor current reporting schemes ensuring absolute accountability, a multi-pronged approach is still necessary. Global Witness, the first exposer of conflict diamonds and one-time proponents of the Kimberley process, publicly withdrew its support from the Kimberley process years ago for numerous reasons, but emphasized the need for the diamond industry to step up. They suggest that diamond industry officials should conduct supply chain due diligence in the manner of the Dodd-Frank reporting requirements. Going forward, a second wave of anti-corruption effort is needed in the natural resource sector. One possible way to introduce more accountability is by expanding the reach of laws like the Lacey Act amendments or the Alien Tort Statute by mimicking Foreign Corrupt Practice Act enforcement. FCPA-like laws have been adopted around the globe, and many large firms now have FCPA practice groups. If the widespread adoption of the FCPA is any indication, the world is ready and eager to promote good government and anti-corruption efforts abroad. Expanding these laws to cover sourcing of other natural resources could raise the profile of U.S. anti-natural resource exploitation efforts and give the U.S. an opportunity to right the wrongs of the Dodd-Frank DRC provisions. They could take time to consult other efforts and civil society groups to determine the best ways to address each resource crisis instead of putting a de facto ban on one major source. This model is worth pursuing further across natural resource exploitation schemes to give it more teeth to good governance measures and promote a presumption of compliance and transparency both in the U.S. and abroad. Additionally, an improved Kimberley process can easily be incorporated into a due diligence framework to ensure that diamonds and other minerals are sourced responsibly. If you're tuned into the conflict minerals world, you've probably heard that the administration is considering a suspension of enforcement of the Dodd-Frank conflict minerals provisions. And if the White House doesn't do it, congressional Republicans are expected to try to defund the program like they did last year. Interestingly, the conflict minerals standard was originally proposed by then Senator Sam Brownback, one of the more conservative voices in Congress at the time. He saw it as a way to help defund militias, but the tone of Congress on Dodd-Frank has since changed. Luckily, government and civil society are not the only actors on the stage anymore. Advocates for conflict-free minerals have gained, through Section 1502 enforcement, some unlikely allies. Intel, Tiffany & Co., and Apple have all come out in support of continued regulations of conflict minerals. Why? Because, as the Washington Post reported last week, the law has created an expectation that wasn't there before. An expectation both inside corporate headquarters and among consumers that their products will be conflict-free. Now that they have adjusted their corporate cultures, they don't want to back away from the change, and they want the law to stick with them. In a statement, Apple committed to continuing its conflict minerals compliance. We do this because it's the right thing to do, regardless of whether or not the law requires it. So mine is not just a cautionary tale, it's an inspirational one. Some advocates saw a problem, they proposed a legal solution, and these steps have changed the culture and awareness of major American corporations as a result. They have made the DRC a safer place to live, creating real change on the ground. As Shannon said earlier, Georgetown's motto is law is but the means, justice is the end. And there is so much more room for justice in the natural resource sector. Thank you.
Okay, so Caroline Kelly is our next speaker. Caroline is a 3L at Georgetown University Law Center. Here at Georgetown, Caroline is a member of the Global Law Scholars Program, was a human rights associate with the Human Rights Institute, participated in the Center for Applied Legal Studies Clinic, where she represented a refugee in asylum proceedings in the United States, and serves as an executive editor of the Georgetown Journal of International Law. Her work experience includes interning at the United Nations Human Rights Council in Geneva, conducting research at Alberto Hurtado University in Santiago, Chile, and interning at the Department of Justice Criminal Division, Office of International Affairs. She received a Bachelor of Arts in International Studies with a concentration in Ethics and International Social Justice from Boston College. We are grateful to have Caroline here today to present her paper entitled Contextual complementarity, assessing unwillingness and genuine prosecutions in Colombia's special jurisdiction for peace. Thank you.
Thank you. Thank you to the Georgetown Journal of International Law for hosting this event and for inviting me, and for all of the staff who I know have put a lot of time and effort into putting this symposium together. So I'm excited to be able to talk to you today about my note. So as many of you probably know, the Colombian government and the FARC rebel group in Colombia came to a peace agreement earlier this year. That agreement was famously rejected on October 2nd by the people in a national plebiscite, very narrowly rejected. The result was about 50.2% of the population voted against the agreement. The agreement was then revised, and the final version was passed by the Colombian Congress in November of 2016. And one of the provisions of this agreement was to create the Special Jurisdiction for Peace, which is a framework for holding individuals accountable for violations of international criminal law, such as war crimes and crimes against humanity. One of the more controversial provisions of the Special Jurisdiction for Peace is that it creates the possibility that certain individuals who come forward and confess their crimes and accept responsibility will receive special sentences, which are defined as effective restrictions on liberty but not served in a prison. So these individuals would be restricted in some way but not actually serving their sentences in a prison. One question that this has raised is how this will impact the International Criminal Court's preliminary examination into the situation in Colombia. The ICC is currently determining whether or not it has jurisdiction to initiate investigations and prosecutions into crimes that are enumerated in the Rome Statute that were committed in Colombia since 2002. The court has said that it has concerns about these special sentences and that they bring into question the genuine nature of the prosecutions in Colombia. So in order to sort of frame this issue, I thought it would first be helpful to understand a little bit more about the complementarity principle of the ICC. So the complementary principle is based on the idea that the International Criminal Court is supposed to be a court of last resort. Cases are only supposed to come to the International Criminal Court if they cannot be prosecuted for some reason at the domestic level. So the Rome Statute says that a case is inadmissible before the International Criminal Court where a state that has jurisdiction is investigating or prosecuting unless the state is unable to genuinely prosecute the case or the state is unwilling to genuinely prosecute the case. Inability is not a particularly controversial issue. That generally just means that the state lacks the capacity to have trials, either because they don't have enough lawyers, they don't have enough judges, they don't have a strong judicial system in place. A state is unwilling to genuinely prosecute the case. That's a more controversial issue because that generally involves a situation in which the individuals who have committed war crimes or crimes against humanity or genocide still exert political influence in the society, and there's not the political will at the domestic level to hold those individuals accountable. A case is also inadmissible before the court where the person has been tried in another court for the conduct. That is based on the principle that a person shouldn't be tried twice for the same conduct. But there are exceptions to this principle where the proceedings were for the purpose of shielding the person concerned from criminal responsibility, or the proceedings were conducted in a manner inconsistent with an intent to bring the person concerned to justice. So this idea of complementarity is based first on the principle of sovereignty, that states have the primary responsibility to prosecute criminal violations that happen within their territory. And there is sort of a tension here because while states do have this primary responsibility, ultimately, the ICC is going to determine whether those prosecutions are genuine. So a domestic court could prosecute an individual, but the ICC could then step in and say, no, those proceedings weren't actually genuine, so we are going to come in and prosecute that individual as well. This principle is also based on the idea that it's better to have prosecutions at the domestic level. This is because victim communities may feel that they are closer to these prosecutions, that they have more of a voice in the proceedings, that they have more of a stake in the proceedings. For example, in Colombia, thousands of victims participated in some way in the peace negotiations between the Colombian government and the FARC. Victims went to Havana during the peace negotiations to testify and to provide their input on what they wanted to see in a peace agreement. So they feel like they have more of a voice in those proceedings. Also, having domestic prosecutions may help contribute to capacity building, building public trust in public institutions, which may be deteriorated during times of conflict. So while there is this desire to have domestic prosecutions, there's also a recognition that states undergoing a transition after a conflict have a wide variety of goals when they are establishing their transitional justice process. They may be concerned with reconciliation, of bringing divided factions together, of reincorporating rebel groups back into the society in some way, as well as holding individuals accountable. The ICC has more circumscribed goals. They are focused solely on holding individuals accountable for violations of international criminal law. So there may be a little bit of a tension between the goals of the society and the goals of the ICC in this regard. So looking to the text of the Rome Statute and how you interpret this word genuinely, is a state genuinely willing to prosecute the case? The word genuine is not defined anywhere in the Rome Statute. This was a word that the drafters of the Rome Statute debated at great length. They decided that genuine was the least objectionable word that they could find and one that the parties could agree upon without really elaborating on it any further. So what a genuine prosecution is not really clear from the Rome Statute. Based on sort of the dictionary definition of genuine, you can say that it's a prosecution that's free from pretext, that it is meant to hold the person accountable. It's not, doesn't have the underlying purpose of letting the person go free, essentially. Another controversial issue within the Rome Statute is that under Article 20, which is the one that says that a person shouldn't be tried twice for the same thing, there were proposals to have an exception to this where the sentence was manifestly disproportionate to the crime, or where the person was subsequently paroled or pardoned or had their sentence commuted. And all of those proposals were rejected by the drafters of the Rome Statute because they said that that was too much of an interference in the state's political decisions. And there was a concern by the drafters of the Rome Statute that addressing this issue any further would overhaul the entire principle of complementarity. So that they specifically left that out of the Rome Statute. And that means that you could have a situation in which the prosecution is entirely genuine, the prosecutors really do intend to hold this person accountable, but then either the judge issues a very lenient sentence or the person is convicted and gets a long sentence, but that sentence is then commuted by an executive or that person is pardoned. And the prosecution was genuine, so for that reason, the ICC doesn't have jurisdiction even though the person then goes free. And that's sort of a gap in the court's jurisdiction. So looking at the case of Colombia, the Colombian government was nice enough to put together a little chart in English describing how this works. I thought that might be a helpful visual aid. So the first phase of holding individuals accountable for violations of international criminal law is that they go before a judicial panel of acknowledgement of responsibility. And this body receives reports from the Attorney General, the criminal justice system, the legislature, victims' rights organizations, and human rights organizations, and compiles all this evidence of violations of international criminal law. And individuals who are implicated in those reports are then notified and have the opportunity to come before the tribunal to either confess and accept responsibility for their crimes, or they can deny the allegations. If they deny the allegations, then the Investigations and Prosecutions Unit starts an investigation into the person. If at that stage, after an investigation or prosecution has begun, the person confesses, they will be sentenced to 5 to 8 years in prison. If the person does not confess and is convicted at trial, they will be sentenced to 15 to 20 years in prison. If the person confesses at the beginning stage, before the judicial panel of acknowledgement of responsibility, they will go before the Tribunal for Peace and they will be sentenced to 5 to 8 years effective restrictions on liberty. And those are those special sentences that I was talking about. It's not entirely clear what these will look like yet. In the revised peace agreement, the parties did clarify that these restrictions on liberty would be confined to an area no larger than a rural hamlet, but didn't really provide any more details on exactly what people would be doing while they are confined. They had suggested that the people will be performing restorative activities, activities that are aimed at reincorporating them into the society. They had suggested things such as crop replacement, removing cocoa crops that are often used to create cocaine and replacing them with food crops, for example. So that's one possibility of things that people would be doing, but again, it's not entirely clear how exactly this will be implemented. Although they also said in the revised peace agreement that they will have an oversight mechanism run by the United Nations to ensure that these people are truly being restricted in some way and are serving their punishments in a restricted area. So there's a question now of whether these proceedings are genuine under Article 17 of the Rome Statute or if they fall within one of the exceptions in Article 20 to the Rome Statute. And it's not clear that simply because the sentences are not served in a prison, the court can say that these proceedings are not genuine. As I mentioned earlier, the court specifically left out an exception for when the sentence was disproportionate to the crime or when the person was paroled or pardoned or had their sentence commuted. So there seemed to be a desire by the drafters of the Rome Statute to not have the court get involved in sentencing decisions, which makes some sense because sentencing is a very controversial issue globally. How do you decide what is a proportionate punishment for war crimes or crimes against humanity? Is 5 years in prison enough? Is 10 years in prison enough? Countries are going to be very divided on that issue, and that's part of the reason the drafters of the Rome Statute just didn't include it, because they thought it was going to be too political of an issue to include. So you can argue, I think, that if you set out at the beginning that these special sentences are going to be imposed, that sort of undermines the genuine nature of the proceedings from the beginning, but it is, considering the history of drafting the Rome Statute, I think that's a difficult argument. And it also gets the court involved in these very political decisions of sentencing. So the special jurisdiction for peace may not be perfect, but it is the mechanism that the parties have chosen to pursue the goals of establishing the truth, of holding individuals accountable for violations of international criminal law, for promoting reconciliation and reincorporating rebel factions into society, and promoting confidence in the rule of law. Colombia is experiencing what is sometimes referred to as a pacted transition. So this isn't a situation in which there has been a clear military victor. The parties have negotiated what the terms of the transition will be, and in a situation like that, it's very unlikely that you're going to get what is sometimes referred to as the Nuremberg option of full-scale trials for everyone who committed war crimes or crimes against humanity, because the parties simply aren't going to agree to that as the terms of their peace agreement. So this is an attempt to still pursue some type of accountability mechanism in a way that's going to be realistic given the type of transition that's occurring. This isn't a new phenomenon. Countries have been facing this exact issue for a long time and have had various ways of going about it. One of the most common ones up until the end of the 20th century was simply issuing amnesties, blanket amnesties. And the establishment of the International Criminal Court, along with other international criminal tribunals, has demonstrated that the international community will no longer stand for blanket amnesty for violations of international criminal law. But there is a middle ground between full-scale trials and blanket amnesty, and that's what Colombia is trying to pursue here. They are holding individuals accountable. It's just not exactly maybe in the way that the International Criminal Court would like them to. So there's a question of how the International Criminal Court should approach a situation like this, especially given the fact that they do want to promote domestic prosecutions. They want to encourage states to have accountability mechanisms at the domestic level, and recognizing that that is not always going to mean full-scale trials for every perpetrator and long prison sentences for every perpetrator. So some ways that the court can go about dealing with this. The first is by providing clearer standards of what is a genuine prosecution. As I said, this word is not defined in the statute, and the court has given some vague guidelines as to what it means, but it's hard for states to predict how the court is going to react to the accountability mechanism that they come up with when they don't have any guidance on what a genuine prosecution looks like, what the court's standards are for a genuine prosecution. So providing those guidelines will put states on notice as to what those conditions are, what makes a prosecution genuine. It's also consistent with the principle of the rule of law, because if you don't give some sort of guidance on what is a genuine prosecution, that definition could change from prosecutor to prosecutor, and there's no consistency that the states can expect. Of course, you need to balance these clear standards with recognizing that different societies are going to confront these issues in different ways and have different goals. And you want to provide a certain degree of flexibility to deal with the different types of conflicts that you can have. Colombia is one situation that it's been a 50-year conflict. The parties are negotiating the transition. You have other situations like Rwanda where there was a clear military victor. It was a short conflict. It was much easier to hold full-scale trials. So there's going to be sort of variations in the accountability options that are available to societies after conflict. So the key thing that the court can do in that regard is just be in constant consultation with the concerned states, understanding the state's goals, and understanding, are these prosecutions for the purpose of shielding these people from accountability, or is it the state's way of balancing their desire to hold people accountable with a desire such as reconciling the society and establishing the truth? And only by being in constant consultation with the concerned state are you going to be able to figure out the state's motive. Also, being in consultation with the concerned state allows the ICC to provide some guidance to the state, technical assistance, and best practices. The court does not have an outreach or capacity building mandate, which may be a flaw with the court, which there could be a whole other paper about that. But that is something that, at least if it doesn't have full resources to provide guidance to states, it can at least provide some technical assistance and some best practices guidance by being in consultation with the state. The next thing the court can do is provide sentencing guidelines. As I said, it's not clear that the court does have a lot of power over sentencing because this was specifically excluded from the Rome Statute. But the court has said in statements about the special jurisdiction for peace in Colombia that it is looking to the sentences as part of the analysis of whether the proceedings are genuine. And so if the court's going to do that, it needs to provide some guidance as to what authority it has to do that and what the sentencing guidelines are. I would argue that they don't really have much power in this regard, and if they are going to issue some sort of guidance on sentencing, that they need to consult with the Assembly of States Parties to the Rome Statute, and this may require an amendment to the Rome Statute because of how divisive this issue is. Finally, the court can exercise its prosecutorial discretion. The court has limited resources, and it's not going to be able to prosecute every violation of international criminal law that happens in the world. So one thing it can do is to focus on those situations where there is going to be rampant impunity for those who commit violations of international criminal law. Colombia is a case where they are holding people accountable. There's some question as to whether they are holding people accountable in exactly the way that the court wants them to, but that should be a lower priority for them than cases where there are going to be no prosecutions and no accountability whatsoever. So looking forward, Colombia may serve as a model for other states that are seeking to implement alternative approaches to prosecutions, and how the court approaches the case of Colombia is going to provide guidance for states in the future who are also undergoing a transition after a conflict. All states party to the Rome Statute would certainly benefit from a clear understanding of how it can meet its obligation to genuinely prosecute violations of international criminal law. And this guidance may also make it more likely that states who are not currently party to the Rome Statute may join the Rome Statute, which would increase the ICC's jurisdiction as well as its credibility. Bringing this back to the U.S. context, because this is the focus of the symposium, I am not holding out hope that the current administration is going to try to ratify the Rome Statute. That seems pretty unlikely. However, providing this guidance may encourage the United States to join the Rome Statute under a future administration. And I'm happy to take questions.
So you talked a little bit about consultation. Mm-hmm. Is there in a practical sense any evidence people from the ICC are talking to the parties right now?
Yeah. Yes. So the court is certainly doing that already, and I think that's more of just a suggestion of what the court should continue doing and place an emphasis on that as the best way that you're going to be able to sort of figure out the motives of the parties, figure out what their goals are. Have they been engaging with victim populations, or is it just the parties coming to this on their own? And that is something that the court has been actively involved in. They've been in constant communication with Colombia. So I think that's something that the court's already doing and should continue to do.
Is it just very informal, or did the parties approach the court, or how that was initiated?
I'm not exactly sure how it was initiated. Colombia is a party to the ICC, so anytime that there are war crimes or crimes against humanity being committed there, I would guess that there is someone from the ICC who is in communication with the Colombian state to determine how they're dealing with that. especially given the fact that, the conflict in Colombia has been going on for over 50 years. The conflict was ongoing at the time when Colombia joined the Rome Statute. I have to imagine that this has been a conversation that's been going on essentially since Colombia joined the Rome Statute.
Yep. Right. Good afternoon, everyone. Thank you so much for coming out. Again, my name is Noral Kebi, and I'm Georgetown's 2017 symposium editor. Thanks again. So I would like to just give a brief introduction to our next speaker. Alexis Wolpin is a 3L at Georgetown. She is pursuing a certificate in refugees and humanitarian emergencies. Her experience in international law includes interning with a civil society organization in South Africa and participating in an international and comparative business law exchange program in Germany. She also has competed in the Jessup International Law Moot Court competition and the Pictet International Humanitarian Law competition. After graduation, she'll be working at a law firm in New York City. She will be presenting on the note that we are publishing, Floating Armories, the Legal Gray Area in Arms Trade and the Law of the Sea. So without further ado, Alexis, please come up.
Okay. So I'll be talking about a topic that does not get a lot of attention in the international arena, and that is floating armories. So as you may or may not know, maritime piracy is still, unfortunately, a major issue today. This is the definition of piracy in the UN Convention of the Law of the Sea. It's still a huge issue. The International Maritime Organization estimates that, on average, pirates can receive up to $360 million US per year in ransom. And there are still, as of July of 2016, which is the most recent published data, there were 98 reported either attempted or completed acts of piracy in the world. So there are several areas that are listed as high-risk areas, or HRA. In particular, pay attention to the area highlighted in blue. This is the largest HRA in the world, and it is also the area where 40% of the world's sea trade passes through. Obviously, this is a major concern because of the high instances of piracy. So as a response to these concerns, freight operators will often hire private maritime security companies, or PMSCs, to provide protection for their ships. Sometimes these armed guards will actually board the freight ships themselves. Other times they will use their own smaller vessels and kind of form an escort throughout the high-risk area. However, most coastal states do prohibit foreign vessels from entering into their territory with weapons and ammunition. So the solution has been floating armories. These are essentially commercially owned vessels that remain anchored in international waters. How it works, essentially there's many different types. The first type are armories that provide storage only. So the PMSCs will, when they are getting close to a state's contiguous zone, they'll go back, deposit their weapons in the floating armories. The armories will keep them there until they need them for the next time. The second type are armories that provide storage facilities and the weapons themselves. And the third type are the fully integrated security services. These are armories that supply weapons, they supply personnel, they do it all. Just to go back, I'm not sure if I know how to do this. All right, so to go back to this picture for a minute, how this will essentially work is there are three parties involved. The freight operator will hire the PMSC. The PMSC, depending on its needs, will then contract with the floating armory. So what will happen is, let's say a ship is going from Somalia to India. The floating arm, depending on the size of the ship, the quantity or the expensive goods on board, let's say they hire a armory that will give them everything. They'll give them guards, weapons, and storage. So sometimes the armory itself will have a meeting point with the freight ship once it leaves Somalia's territory, and it'll do the exchange there, the exchange of personnel and the weapons. Sometimes the PMSC will have their own ship. They'll have to go out to the armory itself, pick up the weapons. There's no standardized procedure. But essentially what happens is that once the freight ship is outside of Somalia's territory, the guards will enter or come on board with the weapons. It'll escort the ship through the high-risk area, and then once the ship is either out of the high-risk area or once it is approaching the territorial waters of another state, the PMSC will then either meet the floating armory or it will take its own ships and deposit the weapons back to the armory itself. So this isn't illegal, but essentially what this means is that the weapons remain in international waters. So in doing so, it's avoiding national and international laws with respect to arms trade and weapons usage. There is evidence that the number of floating armories does decrease the amount of piracy instances reported. So in July of 2016, there were 98 reported instances. In 2012, which is when floating armories started to become popular, there were close to 500 reported instances. So this does have a positive effect in preventing instances of piracy. However, this comes with a lot of problems as well by virtue of the fact that it is kind of evading laws with regard to weapons usage. So the first major issue is the lack of laws and regulation. Because there are some good practice standards, none of these are legally binding, and because of these lack of laws and regulations, there's essentially nothing preventing any commercial vessel from becoming a floating armory in international waters. Because some states do license floating armories, however, some states such as Sri Lanka and Djibouti don't make these licenses publicly available, so the legitimacy of these licenses are often scrutinized. Also, the weapons themselves aren't licensed properly, so a lot of times the PMSCs, when they rent these weapons from the floating armories, sometimes they'll even rent them out to other PMSCs without the knowledge of the operator. And so the weapons themselves oftentimes either end up in the wrong hands or for uses other than that which was originally stipulated. For example, in 2012, there was a PMSC who lost over 200 AK-47s that belonged to the Sri Lankan government. Those weapons were never found. We have no idea who has them now or what they've been used for. There are also a lot of other safety and security implications because of the lack of regulation. For example, floating armories were seldom actually built for that purpose. Most of them are actually converted offshore tugs or were previously used as dive vessels or research vessels. So the weapons themselves are often stored on the deck of the ship, as you can see from this picture. This is obviously a danger to the crew and marine life as well. However, industry experts also note that a lot of times this means that the armories attract unwanted attention from the very pirates that they're trying to protect against. There have been over 12 instances in 2016 alone of pirates attacking floating armories and stealing these weapons. There are also no standardized procedures for use of force or for recognizing an enemy. In 2012, this was actually a PMSC that had rented out weapons from a floating armory. They saw a ship approaching, so they decided that it was an enemy that authorized them to use lethal force, and they ended up killing 3 innocent Somali fishermen. And so there's nothing indicating that you need to fire a warning shot or how to tell who is an enemy or who is just another vessel. These obviously pose a lot of issues. In addition, sometimes there are cases where floating armories or the PMSCs using these weapons do end up in the territory of another state. This is either by accident or for need to refuel. While the law of the sea does provide for the right of innocent passage, there have been instances where a state has realized that these ships are entering their territory with weapons and have cited this as a national security risk and have imprisoned the crew members of these floating armories. The second major issue is with regard to the flag of the vessel themselves. So the law of the sea indicates that the only state that can exercise jurisdiction over a vessel while it's in international waters is the state to which that vessel is flagged. However, the Remote Control Project, which has done a lot of really great work on this topic, has found that about half of floating armories that it has detected have been flagged to flags of convenience. These are essentially states that have little or no regulations. Panama and Sierra Leone are 2 prominent examples. They do not require a definition of floating armory, even though they do register vessels for this purpose. So essentially, this means that about half of the floating armories out there are operating with little to no oversight whatsoever. The Remote Control Project has also indicated that many floating armories are Flag 2 blacklisted states. This is, so the Paris MOU is a body that essentially judges the effectiveness of different flag states on how much they regulate, how effective their regulation is, and it came up with a list of blacklisted states, which includes Djibouti and Mongolia, which a number of floating armories are Flag 2. This is obviously another issue because these operators are essentially doing whatever they want in international waters and are not being regulated. And finally, there's a lack of a publicly available registry. So we really have no idea how many floating armories are out there. We have no idea how many and what types of weapons and ammunition are just floating around in international waters waiting to be used. So there are several possible solutions to these problems. The first is the creation of a set of binding rules and regulations. So I've alluded to it before, but there are several good practice standards that exist. Most of these are through the International Maritime Organization. They have several standards specifically with regard to floating armories. These are 28,007, 28,000, and these provide regulations such as what is an appropriate use of force, appropriate training, requirements that you have licenses from the state, a bunch of things specifically speaking to floating armories. And so one suggestion is that all armory operators must receive a certificate from the International Maritime Organization that shows that they are following these regulations and they are requiring that their weapons and personnel are using these weapons properly. Another suggestion is that armory operators must show that they are in compliance with the UN Convention on Stockpile Management. This is a convention that has certain requirements for how weapons are to be stored. So for example, they require that the weapons should be stored in the structure of the ship, so not on the ship's deck. Weapons and ammunition should be stored separately in weatherproof containers with a secured entrance. These obviously must be followed as well. Finally, a requirement is that armory operators should show that they are in full compliance with the Convention for Safety at Life at Sea, which provides certain safety requirements for crew members, such as a specified capacity for crew members. So while some of the armories don't necessarily provide armed guards for the PMSCs, a lot of them will provide accommodation. So in the instances where the PMSC has to now meet back they leave the ship after the HRA, they're dropping off the weapons at the floating armory. Some armories do have several rooms where these guards can stay, spend the night. On top of their own crew, this means that there are too many personnel on board that the ship can handle, especially since most of the floating armory vessels were converted offshore tugs. And the PMSCs themselves must also be held accountable by ensuring that they are not contracting out with any floating armory operators that do not possess these licenses. However, these regulations must be enforced. And so that goes to the second set of solutions, which has to do with the flag of the state. So the Convention of the Law of the Sea does state that there must be a genuine link between the vessel and the state to which it is flagged. While this is somewhat ambiguous language, one suggestion is that it should be up to the International Maritime Organization to determine whether or not there is an existing link and should prohibit flags of convenience if there is no existing link there. There should also be a total blanket prohibition on registration to blacklisted states, even if that genuine link does exist. And this is just done because these states have not demonstrated that they care to regulate such issues such as arms trade in international waters. And finally, a creation of a registry, which would be ideally overseen by the IMO. This should include the names of the vessels, the IMO registration number, which every vessel should have, names of the operators, and the quantity and types of weapon and ammunition on board. This is essential for transparency and for accountability. Of course, the only way to really ensure that states have a motivation to enforce these requirements is through a multilateral treaty process, acknowledging, of course, that this does take a lot of time and states need to be encouraged to want to do these things. There are several steps that states can take in the interim. So the Convention of the Law of the Sea does provide for several exceptions where a non-flag state can intervene and exercise its jurisdiction in international waters. The first is with respect to piracy. So a non-flag state can intervene in an act of piracy. This would be implicated when, in the several instances where floating armories do come into attack. However, what's important here is that that right in the Convention of the Law of the Sea does enable the non-flag state to seize any weapons that pirates may have stolen from the floating armory. So it should be encouraged that non-flag states will seize these weapons and make sure they're kept safe and make sure that before returning them to the floating armory operator that they agree to follow the rules and regulations that we discussed earlier. The second is with regard to vessels in distress. Of course, unless this would somehow put the non-flag state's own crew in danger. This would also be implicated, of course, when the floating armory is either coming into attack by pirates or some sort of natural disaster, and again, to ensure that the personnel and the weapons are being treated and acting accordingly. Finally, there is a right of hot pursuit. Of course, there are several thresholds that must be made for a non-flag state to exercise this right. So this would be implicated when a floating armory does enter the territorial waters or contiguous zone of a coastal state. They must be doing something that violates that state's either criminal or civil laws with regard to arms trade or weapon usage. Then it must be a marked governmental ship that would then have the right to pursue the floating armory into the high seas as long as that pursuit is not interrupted. So this would serve to keep floating armory operators on their toes, make sure that they are acting properly, that when they are near a coastal state, they're aware of their laws and they're aware that the way in which they're operating does not violate any state's laws. And finally, a state is entitled under international law to exercise nationality jurisdiction. So say, for example, there is a floating armory that is flagged to Panama, which does not regulate floating armories. However, the guards themselves, the company that operates them, are from Canada. So if they are operating in a way that is a violation of Canada's arms trade laws, Canada would then be able to exercise its jurisdiction over those individuals when they're back in Canadian territory. So this is another example of a way that states can intervene to make sure that floating armory operators and the PMSCs that use them are kind of on their toes. They're encouraged to implement the standards of good practice. So again, the goal here is not to make floating armories illegal or to restrict their numbers. Rather, the goal is to ensure that they are properly regulated so that the weapons are properly accounted for, they don't end up in the wrong hands, the crew receives proper training, and this is all done to ensure that both the armory itself does not come under attack by pirates and that the weapons end up in the proper hands for the proper usage so that freight operators are able to protect themselves against the growing threat of piracy in the high seas. So unless there are any questions, that is all I have. Thank you.
Good afternoon, everyone. Hi. Thank you all for coming out. Again, my name is Nora Kebi, 2017's editor of the Georgetown Law Symposium. So I would like to introduce Mr. John Bellinger III. Mr. Bellinger is a partner in the international and national security practices of Arnold & Porter K. Scholler LLP in Washington, D.C. He is also an adjunct senior fellow in international and national security law at the Council on Foreign Relations. He's a member of the Secretary of State's Advisory Committee on International Law, one of the 4 U.S. members of the Permanent Court of Arbitration in The Hague, and a member of the U.S. National Group, which nominates judges to the International Court of Justice. He's also a member of the Council on Foreign Relations and the Executive Council of the American Law Institute. So obviously a very, very involved practitioner of international law. Mr. Bellinger served as the legal advisor for the U.S. Department of State under Secretary of State Condoleezza Rice from April 2005 to January 2009. He represented the United States before the International Court of Justice in Mexico versus the United States. We might know this case better as Medellin. I think most of us have probably read it, hopefully have read it, international law, and the Iran-U.S. Claims Tribunal. From 2001 to 2005, he served as the senior associate counsel to the president and legal advisor to the National Security Council at the White House, where he was the principal lawyer for the National Security Advisor and the NSC staff. Without further ado, I would like to welcome Mr. Bellinger to the stage. Thank you.
Well, thank you. This is a small but hearty group here in the auditorium. I hear there are more people watching. I'm tempted to make everybody in the back row come and sit in the front row so that I can call on you all and ask questions. Is that good? All right, very good. And I've got my my follow-on speaker and editor-in-chief, Ben Wittes, here in the front row. So if you don't ask me questions, I know that Ben will heckle. I really do want to allow time for questions so that it will, and since your colleagues are watching online, I do leave it to this hardy band to ask the questions. So, that's really the fun part. So what I decided to talk about were some of the challenges that face the Trump administration as they enter into office. Let me say, I started in the White House 16 years ago this month in the beginning of February 2001, and I had an unusual background before that because I had been a career official, part of the maligned career bureaucracy at the Justice Department before I moved over to the White House in 2001. I spent all 4 years at the White House as legal advisor for the National Security Council. I was in the Situation Room on 9/11. I spent much of my next 8 years dealing with terrorism issues. And then, as you heard, I did move over with Secretary Rice, having managed her Senate confirmation and her transition, this period that we're going through right now, over to the State Department. So I have seen a lot of this movie before, maybe not in quite the technicolor that we are seeing right now, but I have seen the beginning of a new administration which comes in with conservative views on international law, on dealing with the bureaucracy. I have particularly seen how long it takes to get a administration up and going. One of my takeaways for my first 9 months in office before 9/11 was just how few political appointees there were across the U.S. government. We were pretty much fully staffed at the White House, which is a problem that the Trump administration has right now. When I came in with then Dr. Rice to the NSC, our NSC was pretty much fully staffed, but we did have the problem across the different departments that, other than the secretaries and then the deputy secretaries, took a long time to get the departments and agencies filled up. And then I also lived through mistakes made in a first term that then had to be corrected in the second term. So again, I've lived through a lot of this before. Again, not with quite the intensity that we are seeing here just in the first month, but this is shades of some things that I've seen before. So let me talk about some of the challenges facing the Trump administration, and of course we all know there are many. Some of these are pre-existing, and so I'm going to touch on the ones that are pre-existing. Some of the challenges are challenges of their own making. They have created challenges for themselves already, even before entering office, and then just in the month after entering office. And some of those may be compounded based on decisions that are made. A lot of the administration's approach to international and national security law is going to depend on the people that are put in place in the general counsel positions across the different departments and agencies. On the positive side, I have heard a number of good names that may go in to be the chief legal officers or general counsels of the different departments and agencies. And if some of the names that I'm hearing go in, I think that'll be a positive sign because they are solid, experienced people. On the other hand, even if they're solid and experienced people and the decisions on some of these things continue to be made from the White House, then it doesn't matter whether we have good and solid and experienced people in the different departments and agencies. And that is a challenge for those of you all who read Lawfare. It's something that we write about a lot right now, is should one go in and serve right now, because whether one can be effective or will decisions be made at the White House that one is then forced to defend and one may disagree with. So right now, as I said, we're off to a number of challenges already. We've seen the refugee and immigration executive order. We've seen the 3 leaked executive orders that were apparently circulated inside the White House, but didn't go much farther than that after they were leaked. To a certain extent, it may be unfair to judge the administration fully on those because they hadn't been sent around. On the other hand, the fact that those executive orders were even being prepared, and if they had not been sent around the way the refugee executive order was sent around, then they really would have been very problematic. If you weren't following those, everybody's been following the refugee and immigration executive order, the Muslim ban, but the other 3 were, one, an executive order that would have essentially reinstated the CIA black sites. The second, which was sort of my favorite because it seemed to make so little sense, was an executive order devoted only to review of all multilateral treaties, to review which multilateral treaties were not in our interest and the United States should withdraw from, to have an entire executive order on that. And then finally, a executive order that would have significantly decreased the funding of the United Nations and other international organizations. Those 3 executive orders have not been signed yet, but it does give you a sense of at least where some people inside the White House were going. And that's why I say it will depend on when the departments end up having chief legal officers. I can tell you, I think there would have been, for at least from some of the people I know who would go into these positions, there would be significant resistance to some of those executive orders. So with that introduction, I want to go through 4 or 5 different issue buckets of challenges for the administration, starting with ISIS and terrorism and the legal framework, then a word about international tribunals, the International Criminal Court, the International Court of Justice, and then a word about treaties. So let me start with the legal framework for fighting terrorism. This has been an issue that I personally have been working on for 16 years. As I said, I was in the Situation Room on 9/11. I was involved initially in the drafting of the 2001 authorization to use military force. Just to make sure that you all are awake after lunch, who knows about the AUMFs? Generally pretty good. So hands are sort of half up. You sort of know half about the AUMFs. So as you know, the authorization to use military force is the statutory authorization that was passed about a week after 9/11 and provides the statutory basis for basically all of the counterterrorism operations of the executive branch for the last 16 years for the Bush administration and the Obama administration. It authorizes all necessary force against the persons, organizations, and groups who committed the 9/11 attacks. And so on the one hand, it's extremely broad because it's not geographically bounded. It's all necessary force. But it is limited in one important way, and is to the persons, organizations, or groups that committed the 9/11 attacks. So what has happened over the last 16 years as we've gotten farther away from 9/11, it's been harder to say that groups that are spin-offs or new groups that are only tangentially related to al-Qaeda are the persons, organizations, or groups that committed the 9/11 attacks. And I can tell you, even when I was in office, and that's now the last 8 years ago, we spent enormous amounts of lawyer time in the Situation Room debating whether a new group in Somalia or Yemen or elsewhere was in fact covered by the 2001 AUMF. So for years, many of us lawyers have felt the AUMF of 2001 needs to be revised. I wrote an op-ed in the Washington Post about 5 or 6 years ago saying that needed to be revised, and it still does. Now, things have gotten even more complicated for those of you who follow this area, when the conflict with ISIS began, now almost 3 years ago. the Obama administration first said that to use force against ISIS, the president would rely on his constitutional authority, which seemed to indicate that he felt he didn't have authority under the 2001 authorization. And then, faced with the War Powers Resolution 60-day clock, then switched legal theories and said that he was, in fact, relying on the 2001 authorization to use military force connected to the 9/11 attacks to use force against the Islamic State, ISIS. Now, many people thought, including many of us who write for Lawfare, in fact, most international lawyers, except for those in the administration, felt that this was a very weak argument because, in fact, ISIS is not al-Qaeda. In fact, for those of you who follow the area, ISIS was really sort of fired by al-Qaeda, so they were really not the same group. So for the administration to say that they were relying on the 2001 AUMF to use force against ISIS was really a stretch. On the other hand, Congress had refused to pass a new authorization, and so the President Obama, was faced with the choice of either stopping the use of force, relying only on his constitutional powers and basically blowing through the War Powers Resolution, or taking this very strained interpretation of the 2001 AUMF, saying that this authorization passed at that point 14 years ago by Congress to use force against the perpetrators of the 9/11 attack really continued to provide authorization for the use of force against ISIS. So that's where things were. So my first challenge for the Trump administration is that they really need to sort out the legal framework for the use of force against ISIS. I'm not sure that President Trump himself is worried about these things, but his lawyers are going to need to be. Now, when I said that some of the challenges were pre-existing, that's a pre-existing challenge. They may complicate this if the administration does what President Trump has said that he wants to do, which is to start sending people back to Guantanamo again. Because at that point, if any ISIS members are captured and sent to Guantanamo, they will then have the right of habeas corpus. They will then challenge their detention in court. One of the first things that they are going to say is, you don't have legal authority to hold me because the 2001 AUMF was intended to be used against people who had committed the 9/11 attacks. ISIS is a different group and therefore doesn't apply to us. So there are a number of reasons why the president should and his lawyers should revise the 2001 AUMF. It's gotten to be very long in the tooth. It's good government for the Congress to be authorizing the conflict that we're actually fighting right now. But for practical reasons, if the administration really were to press forward with sending people to Guantanamo, which I hope they will not, and I would hope the Justice Department lawyers would argue against that, then there will really be a need to get clearer statutory authority from Congress. So I think that is essentially a first 6-month, if not first 3-month priority for the Trump administration and its lawyers. If they were actually to go further and really engage in good government, it's a matter not of just of fixing the 2001 AUMF so that it applies to the terrorist groups that we're actually fighting, including ISIS, but to really go back and to seek a revision of the War Powers Resolution. So this is actually a useful student note. The War Powers Resolution has been on the books since 1973. It is largely either ignored or stretched beyond recognition by presidents of both parties. I would actually argue that President Obama stretched it far beyond more recognition than even Republican presidents, I think in part because he didn't want to rely on his constitutional powers to wage war, so he wanted to say that he had statutory authorization from Congress. But since he couldn't get new statutory authorization from Congress, he therefore had to rely on old statutory authorizations and therefore was relying on interpretations that were frankly just laughable. And he was doing it so that he could say he was complying with the War Powers Resolution. So a good student note would be, what should a new War Powers Resolution look like? Interestingly, There was a National War Powers Commission that was chaired by former Secretaries of State Warren Christopher and Jim Baker. About 10 years ago, I testified before it, which concluded that the War Powers Act was irretrievably broken and needed to be revised. And they came up with their own text, which was essentially a consultation device. And this is the part that's actually interesting. A couple of years ago, John McCain and Tim Kaine got together to introduce legislation to revise the War Powers Resolution. That didn't go anywhere at the time, but if the Trump administration were really to try to address these legal problems with the legal framework for terrorism and use of force more generally, it would be to both fix the 2001 AUMF with either a broader one and or an ISIS-specific AUMF, and to revise the War Powers Resolution. So that's first challenge. Let me turn now to a couple of international tribunals, both the International Criminal Court and the International Court of Justice. And the question there is, how will the Trump administration address both of those? So there are challenges already for the United States before both of those tribunals. The question is, will the Trump administration work with those challenges or make things worse? So the ICC, so quick primer, the United States, of course, is not a party to the Rome Statute. The Bush administration took a fairly hard-line position in the first couple of years of its administration and withdrew formally its signature from the Rome Statute. John Bolton has famously said that that was his happiest moment when he signed the letter to the Secretary General saying the United States did not intend to become a party. In the second term of the Bush administration, when I was legal advisor at the State Department, and with the backing of Secretary Rice, we took a more moderate, engaged position with the court, basically saying we would work with the court when we felt that it was doing work that was important and useful and constructive. We abstained in the referral of the genocide in Darfur to the ICC, and I gave a whole slew of speeches between 2005 and 2009 emphasizing that we were prepared to work with the court on various of its investigations around the world. So the second term of the Bush administration, very much different from the first term. The Obama administration pretty much continued that. There was continuity in approach to the ICC. The Obama administration did not, of course, submit the Rome Statute to the Senate, said that it was flawed and was not going to send it forward. They did begin to start participating as an observer in the Assembly of State Parties, which is the group of parties to the Rome Statute, and continued the cooperation with certain investigations. So that's sort of where we are up to this point. The question is, what will the Trump administration do? Will they return to a very virulently anti-ICC position that is similar to the Bush administration's first couple of years, or will they continue this trajectory that was started in the second term of the Bush administration, continued through the Obama administration of essentially constructive engagement with respect to investigations that we feel are important? If they were to really take a hardline position, what things could they do? They could stop participating in the Assembly of State Parties. I personally think that's a mistake. I think it's better to be in the room to talk to people than to not be in the room. You can't do very much if you're not in the room. They could seek new legislation, a new American Service Members Protection Act that would go even farther than the one that was passed in 2002. They could start pushing countries who are parties to withdraw. For those of you who follow this area, 3 or 4 different African countries have now withdrawn from the Rome Statute. The Trump administration could try to continue that trend and find other ways to bully the court. A lot may depend, I think this is really the thing to watch, on decisions that are made by the prosecutor, because as you may know, the prosecutor of the ICC is conducting preliminary inquiries into, I see some nodding heads, of the UK's actions in, I think, in Iraq, and the U.S. actions in Afghanistan and Israel's actions in Gaza, particularly if the prosecutor takes the investigation of the United States, but also of the UK or Israel, to the next stage of broader investigations, and were to confront the United States directly, that would, I suspect, generate a counter-reaction from the Trump administration. It would actually generate a counter-reaction from any U.S. administration, whether it was the Obama administration or a Hillary Clinton administration. If the prosecutor were to move forward with an investigation of the United States beyond this preliminary investigation, it would be very difficult for the United States to just look the other way. So I can imagine, though, the Trump administration going farther. So watch that spot with respect to the ICC. Will the Trump administration do things on their own, or will there be a counter-reaction to anything that is done by the prosecutor? And the prosecutor, frankly, has got to think that through. She's got people pushing her to investigate the United States and the UK and Israel, particularly because so many, in fact, all of the investigations by the ICC have been of African countries. On the other hand, if she takes the investigations of the U.S., the UK, or Israel forward, it would ruin any constructive engagement between the U.S. and the court, and would be essentially a self-inflicted wound for the court. So the prosecutor's in a difficult spot. Let me turn to another international tribunal. This one may be one that you're not following quite so closely, the International Court of Justice. There is actually a contested case against the United States that's been brought by Iran before the International Court of Justice. Was anybody aware of that, the Bank Markazi case? This one, I don't have any hands. I can tell you something new. So Iran has sued the United States before the International Court of Justice under the Treaty of Amity between the United States and Iran. I was a bit surprised, actually, to find that we are still party to the Treaty of Amity between us and Iran. And one of the reasons that I'm surprised is that Iran has sued us previously under the Treaty of Amity. In this case, this arises out of the seizure of Iranian assets in the United States to pay terrorism judgments. As you probably generally know from your international law courses, the terrorist victims can sue state sponsors of terrorism under the Foreign Sovereign Immunities Act, and there are probably more cases and more judgments against Iran than any other type of case. In some of the cases, the victims have gotten default judgments in the billions of dollars, and then the search is on to try to find Iran's assets, which has been difficult because overall there have not been very many Iranian assets in the United States, and the State Department has historically blocked efforts to seize their embassy and things like this. A few years ago, though, plaintiffs determined that there were some assets of the Iran's central bank in the United States that nobody knew about. The plaintiffs attached those assets. The Iran, in this case, actually did defend itself. They usually don't, and said that these were sovereign assets that could not be seized to pay a judgment. It went all the way up to the Supreme Court in a case called Bank Markazi. And somewhat surprisingly, although just given how the decision came out in the mix of conservatives and liberals, the Supreme Court said that Iran's sovereign assets could be seized to pay these terrorism judgments. So Iran then promptly sued the United States before the International Court of Justice under the Treaty of Amity, saying that that was a violation of international law and of its sovereignty, And so that case is currently pending. It's in the early briefing stages. Now, you alluded to the fact I had argued a similar case. One of my first challenges in 2005, when I became legal advisor, was when we were presented with the ICJ's judgment in the Avena case involving the 51 Mexican nationals. And the question was, were we going to try to comply with that? And the Bush administration in the second term decided to do so. Secretary Rice persuaded the president that we would try to comply with the ICJ's ruling rather than try to resist it. So in this case, watch this spot. What will, in the next 6 months, the Trump administration decide to do with respect to this case before the ICJ? Right now, it's in the jurisdictional stage. The U.S. arguments are probably strongest on jurisdiction, saying that there simply is not jurisdiction to hear this case under the Treaty of Amity having to do with the assets of the Central Bank of Iran. The United States has hinted about some of its arguments in some court filings in the United States, but has not made any filings yet. They're not due yet in The Hague. So I would hope what would happen, it was certainly what I would do if I were legal advisor, is I would continue to defend the U.S. position. We have good arguments and hopefully win. And if we were not to win on jurisdiction, we're then to go forward on the merits, which is what I did in the Medellin case, even though I had at least some people who said that we should not go forward. So we'll see what the Trump administration does. We've already seen in that executive order that I mentioned on international organizations, at least some people in the White House seem to have significant skepticism about international tribunals and courts. And so I could at least imagine some voices in the Trump administration saying that the United States should just stop litigating before the ICJ against Iran. I personally think that would be a big mistake. Again, we do have good legal arguments. And of course, when the United States doesn't take international law seriously, does not participate before international tribunals when we're obligated to do so, then it makes it very hard for us to criticize other countries like China when they don't participate in the tribunal involving the South China Sea. So that's a second tribunal to have a look at. Let me just end with a few comments on treaties and international agreements, and this is another spot to watch. Let me start with some history and statistics that may surprise you, and then take you to the present point. So the Bush administration, for those of you who followed, or at least was not viewed, at least in Europe, as being a supporter of international law. This was difficult for me when I was legal advisor to try to persuade European allies differently. But here's the statistic. In the 8 years of the Bush administration, we persuaded the Senate to give its advice and consent to 163 new treaties. That's more new international law in an 8-year period of time than at any point in American history. Though many of those were multilateral treaties, treaties on the environment, conservation treaties, arms control treaties, human rights treaties, law of war treaties. Some were bilateral treaties, mutual legal assistance, extradition, a broad array of treaties across a whole large number of different areas. My last 2 years of as legal advisor, we got 90 treaties through the Senate in a 2-year term. That is undoubtedly more new treaties and more new international law in 2 years than at any point in the history of our republic. So, here's something that you probably were not even taught in your international law classes. Each of these treaties has to be personally transmitted by the president. This cannot be delegated. I used to write the memos as legal advisor to the National Security Council to the president, and he would then transmit the treaty to the Senate seeking its advice and consent. So at any point, a treaty goes across the president's desk that he doesn't like and says, why are we doing this? He can stop it. Then there's a second bite at the apple, because remember, the Senate actually does not ratify treaties. Oh, good, you got this right. You get an A+ in your class. The Senate gives its advice and consent to the president's ratification. So the executive branch signs the treaty is sent to the Senate for its agreement, its advice and consent. Then it goes back to the president again to ratify the treaty that he signed with the Senate's advice and consent. So it then comes back to the president a second time to ratify the treaty. So all of these treaties that I was talking about personally went across President Bush's desk. So that's a lot of new international law, a lot of which was multilateral, including on environmental, human rights, and other areas. Since that period of time in 2009, though, we really ended up in a trough on treaties and a new international law. In the 8 years of the Obama administration, only 20 treaties were approved by the Senate. That's probably the fewest in any 8-year term that at any point in American history. So an incredible disparity. Now, part of it, candidly, was we had cleared so many treaties through the Senate in the previous 8 years that there were just not a lot in the queue. The other problem, though, was that the Senate's been getting increasingly conservative and has just not been approving treaties. So this is the challenge, again, for the Trump administration. What is going to be their approach to treaties and international agreements? There are a number of treaties that have been transmitted by President Obama and some even previously by President Bush that are still waiting before the Senate. Will the Senate act on those? Part of that will be, what does the executive branch ask? At the beginning of any new term, the executive branch prepares something called the Treaty Priority List, which is transmitted by the State Department to the Senate Foreign Relations Committee. It says, here are the treaties that are pending before the Senate. This is the order that we would like you to address them in. So watch this spot. Will this administration prepare a treaty priority list, or is it going to just not be interested in any of these treaties that are pending before the Senate, bilateral or multilateral? What approach will they take to treaties? And then, of course, will this executive order that was leaked actually go forward, even informally? I have to guess, candidly, that since there seems to be this spark from someone in the White House that the United States is party to a number of multilateral treaties that need to be reviewed, that whether there's an executive order on the subject or not, there will be some review of treaties. Now, this is highly unusual. I've never heard anything like this. There's always a review. In fact, I used to lead it about treaties that we have signed but not yet ratified to determine whether we want the Senate to approve them or not. That's the treaty priority list. But I have never seen a review of treaties that we are already party to see whether mistakes have been made and that we ought to start withdrawing from them. In that executive order that would have required a review of multilateral treaties, the two treaties that were cited at the beginning in the preamble as sort of the premise for the review were the Convention on Elimination of Discrimination Against Women and the Rights of the Child Convention. Now, we're not party to either of those two treaties. So the premise of this order, which is we're concerned about two treaties to which the United States is not a party, seemed to be an odd premise for a review, but maybe the suspicion was so great that the view was, well, maybe some other multilateral treaties had gotten snuck through during either the Bush or the Obama or other administrations, and do we need to check to make sure that we are party to treaties that are not in our interest? I've actually made some press statements on that saying I am not aware of any treaties that we have become party to in recent years that are not in our interest. I can certainly tell you that in all the treaties that we forwarded to President Bush to transmit to the Senate, the different departments and agencies and President Bush himself concluded that they were in our interest. But anyway, watch that spot with respect to sort of treaties generally, the treaty priority list, possible withdrawal from treaties, and then finally I'll just end with the two international agreements, much in the news, although maybe somewhat less so recently, that are not treaties. One is the Iran deal, and the second is the Paris Environmental Agreement, which is a treaty under international law, but not under U.S. law. It's an executive agreement under U.S. law. So with respect to the Iran deal, that, of course, is not even an executive agreement. It is a political declaration. It's not actually legally binding. So it's not a treaty. It's not an executive agreement. It's not even an international agreement. It's not legally binding. But the Trump administration could still back away from it. I think you recall the president's statements during the campaign that he thought that it should be ripped up. And so the question is, will the president back away from the Iran deal? So that's worth looking at. And then finally, with respect to the Paris Agreement, so that is an executive agreement that has been negotiated under the framework of the UN Convention on Climate Change. It was not submitted as a treaty because the obligations in it were so non-intrusive and non-burdensome that it did not rise to the level of something that needed to be submitted to the Senate. Mr. Trump, as a candidate, again said that he was going to cancel the agreement. That's not a known international law term, to cancel an agreement, but I think he probably means that he would try to get the United States out of it. Now, the obligations on the United States are really minimal. It was basically to announce carbon emissions targets, which the Obama administration did, but the targets are not binding. If the agreement had been written in a way to bind the United States to reach those targets, then that would have turned it into a treaty. But to simply have an agreement that said that we were going to announce targets, it was simply not sufficiently onerous that it needed to be treated as a treaty. So to get out of even those obligations, parties cannot even announce their intent to withdraw under the agreement for 3 years, and then at that 3-year period, if a party announces that it's withdrawing from Paris, then you have to wait a whole another year before the withdrawal is effective. So at least if the Trump administration were to follow the terms of the treaty, it would be 4 years before the United States could actually withdraw even from these non-onerous provisions. The nuclear option, which I have seen bandied about by some, is if the United States, however, were to withdraw from the entire UN Framework Convention on Climate Change, which we've been party to for almost 30 years, then that would effectively, legally withdraw us from the Paris Agreement within 1 year. But that really would be the nuclear option. So with respect to treaties, watch what the administration does with its treaty priority list, with withdrawals, and then we can watch with respect to these two particular agreements, the Iran deal, which, as I just said, is actually not an agreement, and the Paris Agreement. So with that, I will end, and then do we have time for a couple of questions, or otherwise we'll turn it over to Ben?
Sure, we have time for a couple questions.
Great.
I'm curious what you think constructive engagement with the International Criminal Court will look like from the Trump administration, especially in terms of the preliminary examination with the UK and still in the US. Is there anything that the Trump administration can do to persuade the court not to move the investigation stage, or anything else they can do to sort of improve the relationship?
Yeah. So, I think the answer is yes. I think there are some things that they could do, and candidly, I would have expected this under, but this might be sort of the kiss of death. This is what I would have expected under a Clinton administration, is to continue to cooperate in the investigations of countries in Africa where we think they may need U.S. help. U.S. intelligence or other cooperation. and then try to persuade the prosecutor that with respect to the U.S. in particular or U.K. or Israel investigations, that they do not meet the criteria for gravity, which I really don't think they do. The ICC was really intended to not try to address every possible individual allegation of war crimes, but mass murders of the type on Nuremberg. Unfortunately, what's happened now is that every time, particularly a big country like the U.S. or the U.K., but any country does something, then people complain to the ICC. But that's really not what the ICC is there for. So I think it doesn't meet the criteria of gravity. And of course, in all three countries, there have been investigations. Critics will say, well, those investigations were not good enough. Nobody ended up getting charged. But the fact is that there have been investigations. So I would think that would be the way one ought to address it, rather than sort of getting into a public fight with the prosecutor to try to persuade the prosecutor why it is not in the court's interest, essentially, to pick a fight with the United States, the UK, or Israel.
I heard you speak a few years ago at the district court here on something that several things that or a question that you raised was in reference to enhanced security and techniques that the Bush administration that the policy of criminal rights on the security, whether you find legal justification for it, whether it was good policy in the United States, those technical practices that vigorously our allies in the countries around the world don't agree with it or don't understand the reality. And I'm wondering if that same sort of question applies, or we should be thinking about it in relation to the Trump administration as some of his rhetoric and the things that he's doing so far, specifically, truly raise the possibility of bringing back enhanced interrogation techniques, which regardless of what is, regardless of your legality of the practice, that is a serious lack of support by the public and around the world, and then also, so I guess, do we consider that question in terms of Trump trying to bring it back to those practices, and then also in terms of Trump viewing the Obama literature policy?
Yeah. Well, it's a multi-part question, and it's a good question. So I'll say one, I actually just gave a very long speech on this at the annual Lloyd Cutler lecture at the Supreme Court in November, in which I attempted to give some advice to the incoming Trump administration on those very issues, on use of force issues. I mean, I talked more generally about the AUMFs and the War Powers Resolution and international law, but I also addressed your very point, frankly, born of the somewhat bitter experience from the Bush administration, which is that our allies will not be with us if we take approaches to things that they believe are violative of law. And I said in that speech, because one of the things I would hear pretty regularly when I was going around the world and then would report back into the White House, and some of my colleagues would say, well, it really doesn't matter what Europeans think. They don't vote for us. We need to only be responsive to our own people. And you can sort of get that. But the problem is that our allies really do vote for us in a way, because they then decide, are they going to cooperate with us? Are they going to share intelligence with us? Are they going to extradite people to us? Are they going to participate in coalitions with us? And our allies really stopped, not altogether, but things significantly slowed down because of concerns in the Bush administration. And so in this lecture that I gave, the Cutler lecture, I said this to the Trump administration, that in trying to appeal to a narrow segment of a domestic audience, you're going to actually end up as a practical matter, hurting the United States because our allies will then not cooperate with us. So am already hearing from a number of different foreign governments that they have been concerned about these statements about returning to CIA black sites, et cetera, and I think a number of these countries have already been raising this quietly with our intelligence agencies and perhaps with the Defense Department and the Justice Department. Whether the White House listens, I hope they will listen because it really does have a practical consequence. So I'll do one more question, and then we'll get on to Ben. Yep, over there.
I was wondering if you have any thoughts or you're optimistic about the potential for H.R. McMaster to sort of improve functioning of the National Security Council and sort of speak to what the limitations on that would be as long as the president's chief that advised that remains on.
Yeah, it's a good question. It's sort of this, one of the many $64,000 questions. I think a lot of us are hopeful that he really will be a very good and successful national security advisor. I don't know him. He's got a bunch of challenges, though. He does not seem to be as ideological as General Flynn. A problem, which I actually do think is a serious disadvantage, is that he has no NSC experience. He has not served on the NSC. He has not represented his department with respect to the NSC. I have seen through years of NSC meetings, both when I was an NSC staffer and then representing the State Department NSC meetings, the process works best when people have got experience. Part of it is these jobs are so hard that you've got 14, 16, 18, 20 hours a day of meetings and decisions, and unless people are playing very nicely together and you've essentially seen what works, what doesn't, when you should speak, when you shouldn't speak, the process is just not going to work. And since he's never participated in it before, it just makes it very, very difficult. Both Secretary Rice and Steve Hadley, whom I worked for, had both served on previous NSCs. And so that is when the process really works best. So I hope he will actually recruit some more people onto the NSC staff. As one of the fights that we know from some of the candidates, and possibly even with him, was his ability to recruit his own staff, is whether he can bring on some people who have got more experience. And then, of course, then your point is, no matter how good he is or how good the staff is, will the president and the others in the White House listen to him and really give him the latitude that he needs to be the national security advisor and the manager of the process? Or will there be a number of different competing power centers inside the White House that include, not only Steve Bannon, but, some of the Trump family members? So he's got a difficult job. I think one of the first things that I would watch for, he obviously can't change his lack of National Security Council experience. So one of the first things that I'll be watching for in just the next 2 weeks will be, will he choose a different deputy national security advisor or an additional deputy national security advisor? Who will he bring in new people to be the senior directors for each of the geographic directorates? And will he bring in more people who don't just have military experience? Will he try to bring in more people with State Department experience or from some of the other agencies? So, if we see some of those announcements of a strong new deputy who's personally got a lot of interagency experience and senior directors with that experience, I think that would be a good sign. So I'll leave it with that and turn you over to Mr. Wittes.
Thank you, Mr. Bellinger, for that insightful talk. So now we have, despite the mentioned connections with the Lawfare blog that Mr. Bellinger alluded to, we have Mr. Ben Wittes, the editor-in-chief of Lawfare. So Lawfare, just to give you some background, is a leading national security blog that's published in conjunction with the Brookings Institution. Mr. Wittes is also a senior fellow in governance studies at the Brookings Institution. He's the author of several books and is the co-chair of the Hoover Institution's Working Group on National Security, Technology, and the Law. Mr. Wittes will be talking to us about something that slightly changes tack for us. It's a crime, a violation, and perhaps something very important to some of us that many of us have not heard of before, the crime of international sextortion.
So thanks very much. Sorry, I just lost my voice for a minute. So wait, how do I advance this? Just click on it? Okay. So I don't usually use PowerPoint. I have a sort of near religious objection to it, but I actually have some data, so I'm gonna violate my normal rule and use it. I also want to say I also don't normally believe in trigger warnings, but I'm going to give one. The material that I'm going to be discussing is, at least for sane and normal people, upsetting. And I'm going to try to do it with some delicacy. There's actually no way to make it not upsetting, because it's actually objectively upsetting. And if you're the sort of person who gets upset by these sort of things, just be warned. So normally when we talk about international justice, we're talking about, particularly when convened by a journal of international law, we tend to be talking and thinking about international organizations, the ICC, the various, ad hoc war crimes tribunals. The law we tend to be thinking about tends to be international law. And we tend to be thinking about, when we're thinking about crime anyway, the grossest sort of mass murders, war crimes, crimes against humanity, things that, are very conditioned in our imaginations by, the Nuremberg experience and the progeny of that. And what I want to talk about today is something that cuts in almost exactly the opposite direction, which is crimes that we think of as the most local kinds of crimes that we have. They're sufficiently local that in the American political system, in our federalist system, they tend not to be federal in character. That is, they tend to be prosecuted at the state level. There is no international law of this subject. And I think we're probably many years from people knowing to think about this in the language of international law, the language of international anything, let alone law. And yet what I'm going to try to persuade you of today is that this subject is actually, you should think about it as the cutting edge of some kind of international justice. And that is the cybersecurity of teenagers and young adults. And if that sounds crazy, bear with me, because I think it is a little bit crazy, but that's kind of the world we're living in. So a couple years ago, I was writing a book with Gabby Bloom, whom some of you may know or may have read her work. She's a prominent international law expert up at Harvard. She and I were writing a book about the future of violence, called appropriately The Future of Violence. And we were interested in the problem of drone strikes, right? The ability of a state to reach out and commit an act of violence against somebody in a different state, halfway around the world without ever kind of leaving your kitchen couch or your living room couch. That is, at least if your living room couch is on the Nellis Air Force Base in Nevada. And I started thinking about the question, well, what other kinds of acts of violence can you perpetrate against somebody at that level? And what else can you do to somebody can I do to somebody in Yemen if I'm the United States? So part of the theory of this was drone technology is getting smaller, it's getting cheaper, it's getting easier to weaponize. So how long will it be before I can conduct my own drone operation in Yemen? And are there crimes like that I can sort of already attack somebody who's halfway around the world? Now, some of the answers to those questions are obvious, right? That's what international identity theft is, right? As I was looking into this, I discovered a really interesting story. It's a story of a gentleman in Southern California. He's going to get out of prison pretty soon. His name is Luis Mijangos. And Luis Mijangos, according to a number of press stories, had written some malware to do what the prosecutors colloquially called sextortion of women and girls. A lot of the victims were underage. And he would infect their computers with his malware, and he would turn their webcams against them, turn on their webcams, remotely operate their webcams, get pictures of them in various state of undress, and then use those pictures to coerce them or sextort them into producing pornography for him. Now, the number of victims in this case was what really caught my eye. It was, the FBI stopped counting at around 240. So you're talking about very, very large numbers of victims. The conduct in question was unbelievably brutal. And here's what was interesting. Not all of the victims were in the United States. And this struck me as a really interesting fact. This was the first time, I think, I could identify in human history where it was possible to commit something like a sexual assault, as in you are actually coercing somebody to engage in sexual activity who is not in the same country as you are. I put together a team at Brookings to try to study this problem and try to figure out how much sextortion there is in the world. This turns out to be a really interesting and complicated question. And it's a question that nobody knows the answer to. So the Justice Department, right around the time we published this study, the Justice Department put out its own document that said sextortion was the single fastest growing threat to children online. And in response to our study at Brookings, Senator Boxer, former Senator Boxer, wrote to former Attorney General Loretta Lynch, asking her how many sextortion cases the Justice Department could identify. And Loretta Lynch could not answer the question. So one of our recommendations in this study was that the Justice Department needs to keep data on this subject. Nobody knows today how much of this stuff there is. So what I want to convince you of is A, that there's a huge amount of it, B, that it's multivariate in character, it's really, really wide-ranging, we'll talk about some of the different kinds of sextortion, and 3, that it's inherently interstate in character, international, interstate, domestically, and international. And so things that we would normally think of as the most local of local crimes, that is, your garden variety sexual coercion, we now have to think about in an international context. All right, so what we did in this study was we looked at cases that we could identify from either the press or from other cases that we had identified. And we were only looking at cases that had been prosecuted. So think of this as the very thin edge of the wedge. This is the largest data set that anybody has ever created on this subject. And as you'll see, it's not that big. And it's not because there aren't a lot of cases. It's because a huge number of them don't get prosecuted and because nobody counts them. By the way, our conditions, our understanding of what a crime is hugely conditioned by what people count. You know, not what counts as a crime, but like what somebody actually takes the time to tally up. We have a sense of what the murder rate is because the FBI and other criminal justice, the Bureau of Justice Statistics, counts murders, right? And they count, we have the uniform crime statistic data. Sextortion is not in the uniform crime statistics data. So it doesn't, so this is a crime that sort of doesn't exist as such. We identified 78 cases. They were almost all, not all, but almost all federally prosecuted. Now that's an interesting fact because that is not true of rape. Okay, so generally speaking, sex crimes are not prosecuted at the federal level, assuming that there's no interstate dimension, that there's no human trafficking, or it doesn't involve children. And some of these cases, a lot of these cases do. Assuming that you're not dealing in child pornography, these are generally going to be prosecuted at the local level. That is not true of sextortion. These tend to be prosecuted at the federal level, and there's an interesting reason for that, which we'll get to. So 3 of these cases are foreign prosecutions. One is from the Netherlands, one's from Israel. The Israeli case is quite interesting, actually. It actually resulted in an Israeli high court opinion. So and I believe one of them is Mexican. That said, don't think that this is an epidemic of sextortion in the United States. This is more reporting about it in the United States. The word sextortion and the basket of terms we were using to find, these are American terms. And there are actually a few categories of sextortion that seem endemic elsewhere. So the BBC, after we did this study, the BBC did a remarkable study of sextortion cases directed at women in the Muslim world and women in Britain, and actually some men in Britain too, who were being extorted for sometimes very large amounts of money, mostly from Morocco. There was a whole call center in Morocco that was devoted to these sextortions. There were also call centers in the Philippines that are running sextortion rackets, a lot of them directed at American military people. So those are a kind of interesting variant of the sort of cases that we're talking about here. Okay, so the experience that we had with Luis Mijangos, where one person is producing a huge number of victims, is actually not that uncommon. So this is 78 cases producing really a bare minimum of 1,400 victims, and I think that's actually deceptive. That's the number of people who were specifically identified in the court documents that we looked at. I think the actual number is almost surely closer to 6,500, and even that may be a low ball estimate, because according to the FBI, one case alone, case by a guy named Ivory Dickerson, may have had 3,800 victims all by himself. So you're talking about, and this is, I think, a really important point, you know, the Silicon Valley term that people use when you when you can do something and then do it again, and the marginal cost of doing it again is very low, right? The Silicon Valley companies call that scaling. And so this is really the first time in human history that sexual violence scales. And it scales for the same reason that Uber scales, right? Writing the code to get the first car to come to pick up the first person and give that person a ride is really expensive. Doing that for the 1,000th person, the marginal cost of that 1,000th person over the 999th is 0. And this is essentially, a lot of these things are pretty automated. And it's really easy once you figure out how to do it again and again and again and again. And if you think about it in comparison to other sexual violence, that's actually unusual, because sexual violence, normally speaking, is risky. It's time-consuming. You actually have to get somebody in an isolated setting, right? You have to, and you take risk every time you do it. And that risk, when you do it again, you assume the risk again, and you have to invest the time again. And so when we think about serial rapists, right, what's a really prolific serial rapist, is 50 people, 50 victims, and that's like memorably horrible. So these people put that, I don't know, to shame? I don't know what the right word is. But the sextortionists, the ones who are prolific with decimal points in a very different place from this. So 13 cases, there were more than 100 victims. And in a few of the cases, anyway, there were, thousands or well more than thousands. So a little bit of demographics of the sextortion problem. I've yet to find a female sextortionist. I'm still looking. This seems to be a perp male problem pretty exclusively. Now, the adult victims are almost all female. So I think when you're thinking about sextortion as a problem among adults, you really can think of it as a species of violence against women and nothing more complicated than that. The wrinkle is that most of the cases involve at least some minor victims, which is why the Justice Department tends to think of this not as a violence against women problem, but as a child exploitation problem. And if you look at the Justice Department's characterization of sextortion, they always treat it as part of their child porn, child exploitation issues. I actually have a real problem with that, and that I've sort of gone back and forth with them about. But I think there is a problem there. And when you look at the cases involving minors, there's a substantial minority of the minor victims are male. And so think of it largely as a problem that involves, mostly child victims, some adult victims. The child victims will be disproportionately, but not exclusively female. The older you get, the more female the victim population is going to be. All right, so how do you do sextortion? This is not a how-to guide, but it is what is actually happening here. So the vast majority of these cases are simple catfishing, social media manipulation cases. This is the overwhelming majority of the cases that involve minors, and it works like this. Somebody Facebook friends you, starts sending you messages, particularly on Kik Messenger and Snapchat are sort of big problems here. But they pretend to be someone who goes to your school. They trick you into sending them a nude picture. Often by sending you one of themselves. You find out later that that is not actually a picture of the person who you're interacting with. And you send one back, and once they have one, they use that to coerce the production of more. It tends to escalate. It starts out with nude pictures. It gets the more leverage the sextortionist has, the more vile the demands become. And it becomes a form of sexual slavery, in some cases relatively quickly. The language that the sextortionists use is interesting here. They don't call it sextortion. They call it slaving. They call it cam slaves. I mean, there's a whole vocabulary that sort of sounds more in slavery than in any of the words I'm using. They will tend to talk about it, and the demands sometimes get very extreme and tend to be complied with. So there's sex involving younger siblings, sometimes much younger siblings, 5, 6, 7 years old. There's been a lot of maiming, and there's been a lot of cases involving animals. So these cases are not, don't think of this as, kids playful sexting. Think of this as, something, awesomely abusive. So the second category of sextortion cases involves password hacking. That is, somebody guesses your password, somebody tricks you into revealing a password by one means or another. They access some body of pictures or whatever that you have from elsewhere in your life, maybe with a significant other, maybe for reasons of your own, and they use that data to then produce, coerce activity. And then the final category, which Mijangos is an example of, it's a smaller subset, is some of these people are very talented hackers, and they will actually, write malware, infect people's computers, and turn their webcams against them. And that's a small subset, tends to involve the adult victims who are a little bit harder to trick most of the time. Okay, which brings us to the international department. And this is, I think, the reason that I'm here today to talk about this. So almost all of these cases, 63% of the cases involve significant interstate elements. That makes this different from other forms of sexual violence, where, usually, unless there's human trafficking, we think of sex crimes as pretty local. Some of them involve a lot of different jurisdictions. And a surprising number of the cases cross international borders. So these are cases in which one of the cases we looked at involved somebody running a sextortion ring out of the U.S. Embassy London. There were other cases of where people domestically had large numbers of victims overseas. And we've actually been contacted by victims overseas wanting to know when their sextortionists were getting out of prison. So there's a communication problem that can exist between our law enforcement and foreign victims. So again, I ask you to think about this as the thin edge of a very large wedge, right? This is what we can see. And 16% of the cases that we're talking about are already international, and the number of victims is in the thousands. All right, and so what's the law we're dealing with? And what you'll see, I don't want to go too much into this right now because it's a little bit beyond the scope of the international dimensions of this, and I want to leave time for questions. But what you'll see is that we're not dealing with international law here. Most states don't have on-point laws at all. The U.S. law, the federal law that we have to deal with this is a strange patchwork of when the victims are children, you've got the child exploitation and child pornography statutes, which are extremely powerful. When there's none of those available, you end up with the normal interstate extortion statute, which has a bizarrely low, for this purpose, 2-year statutory maximum sentence. The workhorse statute in adult sextortion cases is the interstate stalking case statute, which is actually a pretty powerful little statute. But if you think about sort of what morally offends you about sextortion, it's almost glancingly related to the statute at issue. And then finally, for the cases in which you have unlawful access to people's computers, some of these cases, and Mijangos is one of them, get prosecuted under the good old Computer Fraud and Abuse Act, which is, a little bit like catching Al Capone for tax evasion. General statutory problem in the United States is that unless your victims are children, the statutory maximum sentences for these are going to be quite low relative to the extreme abusiveness of the conduct. So the Justice Department the other day actually just got a sentence in a major sextortion case in New Hampshire. It was prosecuted by a woman named Mona Sedki, who I mentioned because she and I did a podcast on prosecuting these cases a few, I want to say over the summer, if you're interested in sort of a Justice Department perspective on this. And Mona, she got a really good sentence for this guy, and it's 9 years. And if you ask yourself about somebody who did in physical space what he did in virtual space, and you ask what kind of sentence one might expect, I think that would be on the extreme low end of what you could expect in those situations. And in our study, we did a sort of comparison of physical world sentences in sex abuse cases and sextortion cases, and the disparities are really quite dramatic. And for present purposes, the relevant point is the United States is in way better shape than most other places in the world in this. So first of all, hats off to the Justice Department. They're actually prosecuting 78 of these cases, which is not, we were not able to find anything like that in any other country. Number two, there are a lot of countries in which it's not even clear that this stuff is illegal. There's the fabric of U.S. law is very dense. And like other cybersecurity, one way to think about sextortion, right, is as a form of sexual violence. Another way to think about sextortion, both accurate, by the way, is that it's a form of data breach. If you're Sony and the North Koreans hack you and that's a data breach, and you get a data breach, like, we know how to think about that. Well, this is data breach at a human interpersonal level, right? You have pictures of yourself that you took for reasons of your own, and you lose control over that, and you become subject to somebody's extortionate demands as a result. There are a lot of countries where data protection law is very weak. And data protection, and this is the sort of the extreme human side of very weak data protection laws. Finally, and I'll stop here, I want to say that we need to think about what international crime is in a much more imaginative fashion. This is stuff that is never going to be prosecuted by the ICC. For, all the reasons that John was talking about the ICC as a prosecutor of big gestalt, the biggest war crimes, right? These are the smallest person-to-person abuse crimes. And the amount that it takes to do one of these cases when there is, that has a significant international dimension is extraordinary. And we have no common definition of the crime, even within the United States, let alone abroad. And what I want to suggest is that this is more norm than exception. That in a world in which we are all communicating constantly with people overseas, a world in which you don't even know whether the people you're communicating with are overseas or not, a huge number of things that we think of as local person-to-person misconduct are actually properly thought of as matters of international justice. And to the extent that we don't expand our concept of international justice, there are a huge number of day-to-day victims of really, really ugly crimes that are going to be without remedy as a result of that. So I'm going to stop there. I'm happy to take your questions in any directions you want to go. Yeah?
So I'm curious if you think that this is a question of where we need international legal reform in order to get better international instruments out there, or do you think that there's room for example, the Palermo Protocol or anti-trafficking
Right. So, look, I mean, I think we are not going to have the International Sextortion Convention anytime soon. And we shouldn't delude ourselves about that. And so you're inevitably in category 2, at least in the short term. I think the fact that people look at this problem and are kind of shocked immediately by the international scope of it, means that over a relatively short period of time, we need to sort of radically accelerate the degree to which we talk about this in international terms. Now, we have not, except within a certain group of countries, we have not developed we've done better in the human trafficking department than we've done in the cybersecurity department, right? And this is a kind of hybrid of the two. And so the question is it a way to use some of the progress that we've made in the human trafficking world to bring into a sort of more modern discussion, more useful discussion, the cybersecurity matters? Or conversely, as I worry, is it that the cybersecurity, the hampered international cooperation on cybersecurity will actually drag down some of the other stuff? So I looked at, in this study, only at cases in which, and I did this intentionally, only at cases in which the demand of the victim was a demand for sexual activity. So if the sextortionist is demanding money, we excluded those cases from our sample. There is a large industry of people who use sextortion to demand money of people. The going price, I mean, it's large enough that the Navy Criminal Investigative Service had to issue guidance to active U.S. service personnel because so many of them were sending, and these were, not kids. These are, like adult members of the military, Navy in particular, who are being approached on Facebook by beautiful young women who send them topless pictures or nude pictures and ask for a similarly revealing shot. They get it, and then the beautiful woman turns out not to be a beautiful woman and turns out not to be, right down the street, but turns out to be a call center in the Philippines that wants $10,000. That's another form of sextortion, and it's quite rampant, and it's, costing people a lot of money. Now, the more dangerous version of that one is what the BBC was writing about in the set of stories they did over the fall, which is this seems to be run principally out of Morocco. It's a town in Morocco actually runs this operation. And what they do is they go after people generally from Muslim countries, but also from conservative Muslim communities in Britain. They get somewhat revealing. They're often not revealing to a Washingtonian, but they're, in context provocative. And there are people who are having to pay very large amounts of money in an ongoing way out of fear for their lives if those pictures become public. And so there's a lot of different dimensions of this. And to go back to your question, some of them, I think, have more capacity to develop kind of working protocols than others. The core problem that I'm concerned about, which is active sexual coercion, I think is probably one of the least amenable to working measures because people have such a strong instinct that there's something wrong with having had those pictures taken of you to begin with. And there's really a real difficulty in getting certain groups of people, law enforcement in lots of countries, to take seriously the idea that there's a protection that needs to happen for whole categories of the victims. I give our Justice Department and FBI a lot of credit. This has not been a problem at the federal level in the United States. Yeah.
You mentioned that there was an Israeli high court opinion that resulted from these cases. Did they deal with that particular instance differently from U.S. courts?
Well, so what's interesting about the Israeli high court opinion is that it produced a written opinion. So there's almost no case law of sextortion in the United States because by the time the FBI knocks on your door, they have you dead to rights on so many counts that basically none of these cases has ever gone to trial. They tend to plead out pretty fast. And that's, by the way, true of, one of the things about sextortion, one of the only things that's a relief about it is that the entire record, the crime is a set of internet transactions between computers. So once they've identified a suspect, it becomes very easy to track. So it doesn't tend to produce, written opinions because there don't tend to be appeals. There are a few exceptions to that, so what was interesting about the Israeli High Court opinion is that it's actually a judgment in a live criminal case that went to trial, and what I thought was interesting about it was that again, there's sort of it's not clear what the relevant law is, but the Israeli judicial reaction was very, very similar to, as was the case in the Netherlands, just sort of very similar at a sort of, wow, this is an incredible violation. There does seem to be some internationally cross-cutting privacy norm that is, brutally offended by the conduct. And so I thought just having a written opinion that kind of explicates the way the court understands what the crime is itself interesting. Yeah. Oh, that's a really interesting issue. So that's actually an issue that in my other life I have written a lot about, not with respect to this stuff, but with respect to some other areas. Look, the technology companies are a very variable lot in regards to this stuff. Some of them have been really excellent, and some of them have really worked hard to make their platforms less amenable to this. And I find it hard to believe that would give rise to serious civil liability, particularly because they are immunized by Section 230 of the Communications Decency Act. Some carriers are on active parts of the problem. And has anybody here ever heard of an online, of a social media site called Omegle? So Omegle is a social media site whose slogan is "Talk to Strangers." And I'm not saying it was designed to help sexual predators access teenagers, but I am saying that if you were going to design a social media site for the express purpose of making sure that sexual predators can access teenagers, it would look a hell of a lot like Omegle. And actually the disclosure, the disclaimer at the bottom of the front page of the site last time I looked had language that said somebody who's got a computer open can look it up. But I think it's probably still true that it says, this is pretty close to an exact quote, "Human nature is inherently unpredictable. Sexual predators have been known to use Omegle. Use at your own peril." And I think they may as well have also they didn't, but they may well also have included Section 30 Communications Decency Act, so ha, 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 right? And I think, some of the companies, and I think Kik honestly bears a lot of responsibility here too. Some of the companies should have more civil liability concerns than they probably do. And I think there are a lot of reasons why I believe in having some safe harbor under 230, but the idea that you can run a site like Omegle and and have no concern about litigation exposure does trouble me a lot. Yeah. Yep. No, so actually, I think some of the most vulnerable, some of the most awful victim cases are actually young gay teens. And some of the worst of the offenders are quite indiscriminate in the gender and sexual orientation of the victims. There was a case, one of the worst cases. The perp had, thousands of victims, and actually said in an FBI interview that he couldn't remember any of them individually anymore. They were just, they were interchangeable in his mind. And a very large percentage of his victims were young boys. And I actually think there's a particular concern. The younger the kids get, the less predictable their genders are. And I think it's as they age, right? So then it looks more like sort of classic violence against women. And then I think you do it becomes more hetero, right, as you get older in the victim population. With the younger kids, it's just people who would go after kids, right? And that becomes, and there's a bunch of the kid victims who, these are awful cases, who, go to a gay chat room sort of for the first time, and there's somebody lurking there who, so I would really urge you not to think of it, particularly as you're thinking about it with respect to child victims, as an exclusively heterosexual environment problem. All right. Thank you all very much.
All right, thank you all so much for attending. That wraps up our speakers for today. If you will join us outside in the lobby, there is going to be a small reception, and we hope to see you there. Thank you, Mr. Bellinger and Mr. Wittes. Can we give them one more round of applause? Thank you all. See you tomorrow.